families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to Families Divided TV. In tonight's episode, retired Israeli judge Philip Marcus is going to be speaking with us on a very important topic that we all need to take notice of and really be made more aware of. The psychological and emotional effects of parental disputes, separation, and divorce on children are often severe and may last well into adulthood. As part of a program aimed at reducing such ill effects to a minimum, members of all professions and also courts dealing with cases involving children have an important role to play. In light of the possibility of harm to children, academic and professional research, as well as experience, show that cases of this kind need to be handled differently from ordinary civil cases. This is especially the case where one of the parents alleges that the other is interfering with contact and the relationship with the child. Many of you are going through this, and many of you get it. So I hope much of what Judge Philip Marcus speaks to us about tonight resonates with you and helps you understand in a much better light. We're going to be right back with Israeli Judge Philip Marcus right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello, everyone. Again, I'm truly grateful to Elaine Cobb for inviting me to give another talk in this series. Those of you who've heard my previous talks will understand where I'm coming from, both geographically and in the sense of my position in the system regarding children and the way they might be affected by parental separation and divorce. I'm from Israel. I started my legal career in England, where I was born. We moved to Israel in 1978. I requalified as a lawyer, and after 15 years in private practice dealing with family matters, among other things, I then spent 17 years as a judge, most of that in the family court, dealing with disputes of all kinds, but also those involving children. I took early retirement in 1995 in order to engage in 2012. I was appointed in 1995. I took retirement in 2012 in order to engage in research, writing, and lecturing on a variety of topics to do with family courts, how family courts should approach cases involving children in a way which is better, and also on what happens to children when parents separate. So I'm going to be speaking today about an urgent need for training, particularly for judges, but also for other professionals, because in my experience, and particularly having spent almost a month in the United States earlier this year, I discovered that one of the principal criticisms and complaints about the court system, but also about other professionals who are involved with cases involving children, is that they need training. They need training in the specifics of cases involving children. And I'm talking here about medical doctors. I'm talking here about teachers. I'm talking here about social workers and psychologists, and more particularly lawyers and judges. The reason is that cases involving children are different from the general run of cases. They're different from general cases involving medical people, and they're different from the general run of civil cases which most lawyers and judges are trained to handle. And even in the educating professions where they're dealing all day, every day with children, they do not always understand the complexities which arise when a child's parents separate and divorce, particularly, but not only, when the separation and divorce are involve harsh words and harsh behaviors. And therefore, I've devoted a good deal of my time in the last few years to developing seminars, developing courses for professionals of all kinds in order to get them up to speed. Let me tell you a little bit about my work with doctors, particularly family doctors, and with pediatricians. My experience with them is that they are all professional in their fields. They understand what they need to know about diagnosis. They understand a little bit about prevention, and they also understand how to treat illness. But when it comes to children and generally families that break up, they are often not aware of the dynamics. They're often not aware of the pressures. They're often not aware of the legal ramifications of what they're doing. One question that comes up is what happens if one parent always brings the child and to the doctor, and the doctor wants to recommend some procedure which is more than just giving a prescription. To what extent should the other parent be involved? And what happens if the parent who brings the child says, well, we're separated, or we're divorced and I've got custody? Does that affect the ability of the other parent to be involved? Does that affect the responsibility of the doctor to get consent from the other parent? Now, these things may differ from one jurisdiction to another, but certainly these medical professionals need to be aware of what the law says in their jurisdiction. And this was particularly the case. There were a number of cases all over the world about inoculation when we were coping with the COVID virus. And many doctors found themselves either giving the wrong advice or not understanding the complexities. And that's just a simple example. When it comes to professionals in the education field, talking about teachers and educational counselors, principals, and others, in many cases, they might find themselves being manipulated by one of the parents who speaks badly of the other parent. And if the people in the school are not fully aware of the effect that such things might have on the child, and they may get built into the issues and may in fact exacerbate the problems. My understanding of what happens in courts and judges is, of course, affected by my professional career, but also by speaking to judges and lawyers from many, many different countries. I'm involved in an organization called Two Wishes. Two Wishes was set up 3 or 4 years ago by Professor Nick Child, who is a retired child psychiatrist from Scotland, and Dr. David Curl, who is a filmmaker, but also a publicist, and has set up a quite successful organization in Australia called For Kids' Sake, and myself. And we've put together a law and justice advisory board, which consists of judges from many different types of jurisdictions. So we have, I'm co-chair with a judge from Belgium. We have involvement of a judge from India, a judge from South Africa, a judge from Scotland, and a judge from Portugal. The judges from Portugal and Scotland have recently left the advisory board, but they are still involved in a different capacity. But we now have a judge from Arizona and a judge from Japan who have joined this board. And we have been discussing court systems. We've been discussing how courts and judges handle cases involving children. And we have found that there is a great deal in common. That to the extent that we've now produced a discussion document, which we've distributed to judges in many other jurisdictions, in which we've given a number of headings of things where we think family courts ought to be functioning, and in which in some places they don't function at all. In some places they deal with things in a way which is no longer consistent with how what children need, and also no longer consistent with the up-to-date research, both the academic research and the research by professionals in the field. And one of the things that we have found is common to practically all jurisdictions is that judges have insufficient training in the areas that we're talking about, and that is something that ought to be remedied. I'm going to speak now about a program that I've developed for seminars for judges. But that can be adapted, of course, for lawyers and for members of other professions. And if any of those listening to this are interested in learning more about how I am proposing that there should be seminars and teaching for judges and others involved in the court system, then please be in contact. I'm sure Elaine will give you my email address. Those of you who want to take it down, it's philipmarcusjurist@gmail.com, and I'll be happy to share my programming and indeed to give seminars by Zoom or in person, and also obviously in collaboration with whichever court system you are familiar with. The foundation for what I'm saying now is that cases involving children are not the normal run of cases which lawyers and judges are trained to handle, unless they are specialists in the field. And in many, many jurisdictions, the judges are not specialists in the field. That's no criticism. Each jurisdiction has its own method of electing or appointing judges, but it's no secret that many, many, many judges do not want to handle family cases, either because they feel that there's too much at stake or because They have their own family issues which might be unresolved from their childhood or even from their adulthood. But nevertheless, they have to deal with cases involving children. My experience shows that there are, in fact, three different categories of judges. There are judges who are specialists in family law. They've practiced in family law before they were appointed to or elected to the bench. They are devoted to dealing with family matters in a way which will better look after children. And they are prepared continuously to learn and gain information and experience from outside the legal profession, as well as from what's going on in the law in their own jurisdiction. Those judges clearly will need in-service training, but they come to the profession of adjudicating cases involving children with a good background of knowledge and experience. That's the case, for example, in Israel, where in order to be appointed a judge in the family court, you are required to have knowledge and experience in family law and in associated fields. There are pre-appointment seminars. There is an annual seminar which all family court judges are required to attend, in which various issues specific to the work of the family court are addressed by experts from the legal profession and legal academia, but also from outside, from the associated professions. So that in a seminar like that, once every 2 or 3 years, it'll concentrate on matters involving children. So there might be lectures from welfare officers and social workers, psychologists and psychiatrists, mediators and parental counselors, so that the judges are kept up to date with what's going on around and inside the legal profession. And these are the judges who need training, but in-service training, because they come to dealing with family cases with this background. In addition, in Israel at least, and in other countries, a judge who is posted to the family court knows that he or she will be sitting in the family court for 5 or 10 years, dealing almost exclusively with family cases, and will be prepared to devote herself or himself to dealing with family cases. And that, of course, means that in the family court, there may be a number of judges, some more senior, some more junior, but they'll be learning from each other and they'll be working together in order to develop best practices. When I say best practices, I don't only mean how you try the case from a legal point of view, but also how to manage it, how to offer and indeed insist that parents who are involved in these cases should receive guidance and should be diverted to mediation or to conciliation, and how the judges also can, either themselves or by referring parents to other agencies, ensure that the parents really understand their responsibilities to the child. They understand how fighting a case in an adversarial way is highly likely to damage the child, who is already affected by the loss of his happy home, and also how to conduct the case in court. One of my colleagues, or a number of colleagues, have said that the first appearance of the parents before the court can be exceptionally influential in how they regard the process. A judge who has experience in the field will know how to speak to them, will be able to look past any manipulations that may be going on by lawyers, and should be able to address the parents directly and give them guidance and an indication of what the appropriate attitude and approach ought to be when handling the case involving their children. There's a second category, however, and that is judges who are assigned to family court for a short time, sometimes immediately after they've been appointed or elected to the bench. And these judges may have no background whatsoever in family cases. They may not be even vaguely familiar with the child development and child psychology structures. They may know little or nothing about mediation in family cases. And these judges, in my opinion, before they start to hear family cases, need a proper orientation so that they will understand that family cases are different from any other case they may ever have dealt with. They may not even have taken a family law course in law school. And I've been told that in some jurisdictions, family court is the first place a rookie judge goes to. He knows he's only going to be there for a couple of years. He has no incentive to learn and to familiarize himself and to make himself expert in the field. And he's going to be dealing with cases because he's a rookie without any experience in how to run a courtroom, as well as the special factors involving family cases. So it is, in my view, essential that a judge who is going to be sitting in family court, even for a short time, should have to take or be involved in a seminar in which he'll be alerted to the effects of family stress on children, the effects of family strife and family proceedings in court, in order that he can more efficiently deal with the case. And in fact, after having received this orientation, it's reasonable to presume that the judge will deal with these cases more quickly and with better expertise than somebody coming to it with no experience whatsoever. So that's the second category. And if my view is in any way acceptable, I would say that everybody involved should be insisting that a judge who is going to hear family cases should have this orientation, a seminar. A day is probably enough in the initial stage, but also in-service training and refreshers, and that's, in my view, essential. There is a third category, which I was exposed to on my recent visit to the United States, and that is a judge who's elected or appointed to a small jurisdiction with a relatively small population. He may be one of only 2 or 3 judges in that county, and he is going to hear all cases of all kinds, including criminal cases and traffic cases, civil cases, building disputes, contract disputes, and also family cases. These judges are in a different category because although they may come to the family cases with little background, they know that they are going to be hearing family cases for several years until they are promoted or moved to a different jurisdiction. For these judges, unlike those who know they're going to be rotated through family cases and they're never going to see it again, these judges probably have more motivation to learn about how to handle these cases, how best to ensure that children are being properly treated, despite the fact that their parents are involved in disputes. And again, I say that what all this means is that there should be professional training for all judges of all kinds who hear family cases, and all those who are involved, all those who are involved in legislation, all those who are involved in court administration, lawyers and citizens who are involved in these cases, they should see as a matter of priority to try to put forward these training schemes as being essential. Specifically, what would we be looking at in these seminars? So first of all, triage. Triage is a word that's borrowed from the medical profession, and it involves allocation of cases and timetabling, which is suited to the special sensitivity and urgency of each case. That needs to be done under the supervision of the judge. And in Israel, for example, we have a system whereby in any case where there's an allegation of abuse or neglect of a child, or of interference with contact between one parent and the child, the case is automatically referred to a judge who will fix a hearing in the presence of the parents within 14 days of filing. And this enables the judge to understand a little bit about the case. He can speak to the parents and understand from them what are the pressures and what are the difficulties. And he can also impress on them the necessity to take responsibility for looking after the children, joint responsibility, depending, of course, on what the law says in the jurisdiction. There needs to be guidance as to how to involve the child. I heard a lecture by a judge from America many years ago, Judge Shudson, who talked about a child having to sit on cushions in the witness box and being interrogated by lawyers, and seeing the judge sitting high up above him, dressed in a black robe like Darth Vader from Star Wars, and how this is a terrible experience for a child. We've moved ahead from there, but there need to be proper arrangements that the voice of the child shall be heard, not because we are going to decide on the basis of what the child wants, but to give the child the feeling that he or she has been involved in the case, that his opinion and his situation is going to be considered together with all the other evidence and submissions in the case. There needs to be guidance as to how to collaborate with members of other professions. Judges may not know the different orientations of psychologists and social workers. They may not know how to appoint an expert witness and what to expect from an expert. And when an expert gives a report which is full of professional words and professional jargon, the judge may need guidance as to how to understand the words and the phrases which are being used. The judge dealing with family cases needs to know how to frame orders that he's giving to the parties so that they are clear and unequivocal. And the judge also needs to know how and when to exercise powers of enforcement so that the work of the judge will not be a laughing stock because orders are being given and they're being flouted without any kind of penalty. I heard of a case in which one of the parents was supposed to be allowing contact, and there were 53 separate violations, and there was no response by the court in terms of punishment or making the parent comply. So judges need to be told that it's important for them to handle matters of enforcement of orders and how to go about it in the way which will least damage the child. Also, there needs to be a special part of the seminar as to how to deal with cases involving child maltreatment, where there may be other jurisdictions involved. There may be a split between the family court and the children's court or the minors court or the juvenile court, which deals with dependency and child protection. So there needs to be help for the family court judge as how to share the work and how to work together with these things. And there are other topics which need to be covered. And as I say, I've organized courses for professionals in many different fields, and I'll be happy to share my knowledge about these things with anybody who is interested. To sum up, there is a need for change in many jurisdictions. The change needs to be handled in a way which does not offend or degrade the judges who deal with these cases to the best of their ability. And there are many, many judges like that. And I think that many, if not most of them, would welcome the kind of guidance that I'm suggesting. Therefore, as I said, everybody involved in these cases should take on the task of trying to encourage and promote this kind of pre-appointment and in-service training for those in the courts who are handling cases involving children. And as I say, this applies to other professions as well, where the sensitivity of cases involving children, you may have heard lectures by my colleague Mary Alvarez, who's spoken about what really happens to children whose parents separate and divorce, and particularly where there's interference with contact. These effects are quite dramatic. These effects are extremely harmful. They last into the adulthood of the child who was affected. And that's why another reason why this training is needed. Again, my thanks to Elaine, and I'll be happy to answer questions by email. Thank you very much.
On our next episode of Families Divided TV, Dr. Stan Carosi discusses the ideologies and forces that are reshaping our families.